In due time. Let's talk about the Supreme Court and what's coming up. And I had Becky Curry on with me yesterday, and Becky was the author of the bill that will actually be, it's kind of historic. Her bill is going to be the one being taken up through the auspices, of course, the State Attorney General Lynn Fitch, and making its way to the Supreme Court as far as the heartbeat bill. And that is coming up maybe in October. And there's going to be a lot of eyes and attention on that bill, of course, certainly now because of the Texas decision by the Supreme Court. Speak to that.
Well, yes, there is an expectation that this will be the most consequential abortion decision since 92, since almost 30 years, since the Casey decision reaffirmed Roe almost 20 years before. I don't think you can make a pattern out of 3 incidents, but if you could, it's a 1 in 20-year pattern, roughly. And we won't get the decision people expect until the last day of the court's term, June 2022. So there'll be lots of time to speculate, lots of time to look into the oral argument and believe we can discern patterns, trends, and outcomes.
Well, you always have the pro-choice people fighting against, of course, the right to life people, and this one is going to, if they rule in the affirmative, set a particular date as far as what is and what is not life, as far as the heartbeat is concerned.
Maybe. That's certainly a possible and perhaps likely outcome. Just because the case is argued the way it is, which is overrule Roe, it doesn't mean that the court's going to take this as a vehicle to affirm or overrule Roe. It's been clear for some time that Justice Roberts would prefer to dispose of Roe by limiting it and suffering kind of death by 1,000 cuts. And so we'll see whether there is a 5-justice consensus to actually overturn Roe. It may be that Roe is retrenched in a way that allows it to dispose of the issue in this case without invalidating the entire precedent. So I think the legal scholars I've listened to and read are all in agreement that it's a little early to celebrate if you're the pro-life side hoping to overturn Roe. And it's a little early to conclude we know what the outcome will be.
Is there a more likely outcome, Matt, for them to basically say, look, we think the right choice on this one is just to leave it up to the states, and I'm not sure how they get there, but is that a possibility?
That's a possibility. That's the overrule Roe possibility, right? That's the overrule Roe possibility. Leave it up to the states is not attractive if you think there is any component to a woman's reproductive choice that's constitutionally protected for any period of time during the pregnancy. And so the court may very well go entirely in that direction, overturn Roe and give it back to the states. Or it may further restrict Roe, as it's done in the last handful of years, and allow this to continue, maybe until it gets to the Texas law. I'm not sure the Texas law helps the pro-life proponents who want to see Roe completely overturned. I think the Texas law, because I don't think the Texas law is the sort of law that sits comfortably with the Supreme Court. There's an element of that subverts their traditional understanding of the rule of law and its procedures. It's a little too clever by half, I think, for many federal judges, trying to make it difficult to figure out kind of the enforcement question for a court. And so I think if giving it back to the states looks like the Texas law, it makes giving it back to the states less attractive for many federal judges.
What are the definable differences between those as far as the heartbeat and the time element on that? Mississippi and the Texas law.
Well, the Texas law goes further. Goes further back into the pregnancy, and the Texas law deputizes every private Texas citizen to put a bounty on a woman seeking an abortion. And the Texas law contains kind of ambiguities about what it takes to trigger the liability and be involved that I think, again, sit uncomfortably with judges used to normal legal principles, because it's not clear. It kind of upends what we normally think of as accomplice liability, that any person involved in any way and the woman making that choice are potential targets of the lawsuit. I haven't made it my professional mission to read and memorize every section of it, but the enforcement and the breadth of it are really startling. It's clever, but I don't know that if I'm a Supreme Court justice sitting on the edge, and I don't know that we have any, it may be 5 justices ready. We know there are 3 justices ready to overturn Roe yesterday. We don't know exactly the readiness level of Justices Barrett and Kavanaugh, but if they felt comfortable with giving it back to the states, that's a area that isn't going to cause chaos and a kind of a Wild West free-for-all. The Texas law would undermine that confidence.
I agree with you. I think that's probably the easiest way out of that. But should they do this in a way that the pro-life people are happy about it, and it does effectively negate Roe versus Wade, and that's the end of it? Do you think that's the straw that breaks the camel's back as far as the Biden administration and expanding the Supreme Court?
I don't think expanding the Supreme Court's ever going to happen. I just don't think.
You don't?
No.
Why is that?
Now, I think commentators and executive branch officials and candidates can kind of promote it and bloviate all they want, but it takes an act of Congress. It takes an act of Congress. And Congress couldn't agree that motherhood was good if they had to.
Yeah. Well, here's the other thing, too.
They'd argue about the definition of motherhood.
I want to talk to you more on the other side about this one, but even the pro-life judges or the judges who are not that pro-life, whichever their political ideology happens to be as far as the Supreme Court, they've got to look at this and they've got to say one way or the other, we are voting in our decision to say that a heartbeat at this particular time is not a child. And do you think that's going to be, and you can answer this later, well, hey, in this day and time, for these people, is it going to be harder for this Supreme Court to do that than any in the past? We'll talk about that. Also, I want to ask you about the initiative process when we come back with law professor, Mississippi College School of Law. Back with the one and only Matt Steffey, law professor, Mississippi School of Law. Is this a conversation that your students are talking about as far as the Supreme Court's concerned?
Yes, although perhaps less than you think. Yeah. It is certainly on their radar, because the truth is that I think there's a certain ideological component that promotes conversation. It is the outcome of this case is an outcome, say, in Mississippi that affects poor women and poor women only, and very vulnerable young women. Any woman who can afford a bus ticket, an overnight stay, a plane ticket, still has access. So I think the personal threat of the loss of choice or abortion services is at one step removed for most of the people I interact with.
So they would be forced to have the baby one way or the other, and the baby would live.
No, they wouldn't. They could travel to a state that permits abortion.
Well, not if they're poor. So the poor babies would be born.
Right, that's right.
That's a bad thing.
That's right.
And that's a bad thing.
Well, I didn't say that. I just said that,
the thing that tends to...
No, I didn't. I said what tends to stir up my students is things that affect them.
I understand that. But you basically said poverty would save the life of that child.
Yes, and poverty
Yes.
would allow,
Yeah.
but a woman who doesn't want to have that child, who
I didn't
thinks
say
that
that.
child,
Well, do you think the child doesn't want to be
listen,
born?
well, I don't
Hey,
know. I think we could
well,
ask him. And now, listen, there are
at some
circumstances
point
under
you
which
could ask
children
him that.
wouldn't want to be born. Listen, I get you on the major question. I do. I was
Okay.
adopted from a Catholic charity orphanage.
Hmm.
This resonates personally with me. But there are circumstances in which I would not want to live. There are
Okay.
circumstances in which I would not want to live.
I don't even want to go there, but I do want to ask you this. Do you think it's going to be a little bit harder for the justices in this day and time and the makeup of this court to say, even this could go either way, but what my decision is going to be means that those beating hearts could continue to be stopped?
Yeah, I don't think the justices think in the same terms as radio hosts.
Mm-hmm.
I don't.
Oh,
I
really?
don't. Talking to an audience that the justices, to the extent they think in those terms, tend to come out in the great middle of the American opinion, the American public opinion. And the American public opinion is to restrict and retrench, but not eliminate abortion rights.
Mm-hmm.
Now, public opinion is malleable, and it depends on how you ask the question. But public opinion does not line up with the no abortions for anyone, nor does it line up with abortions for all. It is restrict and
all right.
and.
We could talk about this for a long time, but I only got a couple of minutes left. I do want
By
to.
the way, I was told that we were going to talk about the vaccine mandate, so I never know what our.
That's because you're not in the studio. This is, I think, the first time we had you on television.
Oh, I'm happy to talk.
Do you want to? The vaccine thing is something I did want to talk to you about, and also the initiative process. But let's take the vaccine since we have limited numbers of minutes left. So let's talk about that. Dr. Ken Cleveland is coming on in a moment or two, and we'll talk to him at 8:05 about the mandate or the policy procedure that the licensure board puts out. Your thoughts?
Well, I think that it's a mistake to call it a vaccine mandate. It's a testing mandate. You have to test the unvaccinated. That's actually the only thing that's mandated, is to test the unvaccinated. So it's the world's mildest vaccine mandate. There are no consequences for the unvaccinated beyond being tested. Can't lose your job, can't get fined, can't be involuntarily subject to a vaccine. It's vaccinate or test. So it's a testing mandate.
What is the testing mandate? I'm confused here.
Once a week. It is for It's for federal government employees, for recipients of federal money. And again, we don't have the law yet. The law isn't yet written. This is just an announcement by the president.
You're talking about the one for the administration. I got you. But here's the problem with that. Then it puts the onus back on the employer to pay for these tests, and he has to pass those on to the employee.
We don't know that.
Well, I mean, that's what the law is as we have it yet. Now,
we don't have a law.
As you said, it hasn't
have
done.
A law. We could,
it's in the works. It's in the works.
Yeah.
All right.
Yes, but the testing costs are modest. Yeah.
All right. Well, we got through that one pretty fast. Let's talk about the initiative process. Do you think that ought to be changed?
Well, I think we ought to have one. We don't have one, right? It's been ruled unconstitutional by the Supreme Court. We don't have one. I think it ought to be. It's popular. It's kind of a safety valve in terms of political sentiment. I think we ought to have an initiative process that isn't easier, but is easier and more comprehensible than the one that we used to have.
I'm sure there's no one in your class that probably dabbles in the marijuana as we speak.
Oh, no, perish the thought.
I'm sure. They wouldn't do that at MC. There's just no way.
No, absolutely not. I'm sure we're a drug-free school place.
Yeah, is that ventilation fan on in the background in your office there? I thought I saw a whiff of smoke in the background.
Not mine. Maybe some nicotine.
I will say this. I will say hello to Jim Liggett for you, and I thank you for joining us, sir. Appreciate it very much.
It's really
Next time
my
back
pleasure.
In the studio. You got it.